Welcome to my channel. Welcome. Oh, it's not playing. That's my new intro. What y'all think of my new intro? Like, share, subscribe. Now, how do I get this thing down? Oh shoot! I don't want to try. Dang! I hope I didn't lose it. All right. Anyway, shout out to Young Thugs YSL attorney Brian Steele. He was held in contempt the other day, and he's going to jail. But when I tell you he stood up for Young Thug, they had a per se a meeting without the defense between the witness Woody, Little Woody, and his attorney and the judge, and did not invite the defense. Brian still tore off in the judge's behind. And when I tell you there's a Georgia um, Defense Attorneys Association, 25 lawyers came down there in the defense, in his defense. So he goes to, because he was going to put him in jail that day, and came to his defense in 2 hours with a case. Shout out to Ashley Merchant. Because like, I'm not telling you the name because of violation, of attorney-client privilege. And he ready. He took off his jacket. He took off his tie. That's a violation of constitutional rights. And I knew that that's going to lead to an appeal if Young Thug is convicted. I was like, welcome home, Thug. Welcome home, Jeffrey Williams, because the judge messed up. Well, they filed the paperwork to the appellate court in the state of Georgia, and the appellate court says, versus another case, that this has to go to Supreme Court because he has to report to jail on days every weekend. And it's going to the Georgia Supreme Court. Shout out to Young. Everybody want an attorney like that. He did the doggone thing. Let me see if I can figure out. You know what? I'm just gonna play it for y'all to hear. I was like, wow. I should do it off of this phone. I think it's louder. Yeah, it is louder.
The issues that we're going to these crimes, and I think even been convicted of some crimes. It's like, wow, what a horrible guy. And she says later, she's like, we were fine talking to the witness. It was when his pesky defense attorney kept standing in the way.
And they accuse him of being unethical, too.
Yes, for sure.
Yeah.
I spoken with Mr. Melvin. Had I told him that we are going to hammer Mr. Copeland, the state had not made any such communication with anybody.
The state doesn't do that. I don't know about you, but the state doesn't usually tell me when they're going to hammer one of our witnesses, right? It's kind of how it just happens.
No.
So what we are seeing, we believe, is tampering with witnesses. This particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks. And after Mr. Copeland has communicated to this court, he will testify. So watching the goings on as Mr. Copeland is now on stand, it has been publicized, it has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time.
Let's get past that. Let me get to the point. Here it is.
But if the judge tells you it's not, you are technically covered by obeying a judge's order.
He makes that argument later, and the judge has found that it's not privileged. Basically, this is something that potentially should be done in chambers or not in front of the cameras or in a sealed meeting potentially. Right. But what would be the repercussions for the person that was maybe in that ex parte meeting and revealed that information to a lawyer on the outside?
He'd have the same contempt problems that Mr. Steele is facing right now, in that he revealed a confidence out of that ex parte order. But, you know, it's because we don't have the transcript, because we don't know exactly what was said. And we also don't know if the judge specifically said no one is to say anything. We really don't know. And we also don't know who said it. We don't know how he found out. I think we all probably have a theory about how he found out. But, you know, that person certainly could be held in contempt.
So what's interesting to me, too, is like, if it did, it doesn't seem like it did, but if it did come from his client, like one of the co-defendants found out, or maybe even Copeland told his client or something like that some way, and his client told him, well, then it is privileged, and then now you're making him break privilege legitimately. It does seem like it came, even the way he kind of read the rule and worked the words in, where it's things he got in other ways as part of his representation.
Let me go back.
The issue is.
Here it is.
Yeah, okay. But I need you to tell me how you don't tell me that. I understand. I want and I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious. Yeah, and that's why I raised it. It is that serious that we should have been there and it shouldn't have. Sir, that's a whole separate issue. And that's why ex parte conversations are recorded. Why would it be ex parte? It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation. You've never asked this on the court or any court to meet with me and a witness.
So what are your thoughts just generally on an ex parte meeting with the judge, prosecutors, and a witness in the case?
I think it's totally improper.
Oh, this is something that potentially should be done in chambers or not in front of the camera.
Because unless you're sitting there, you're eavesdropping. So you can't. Well, hey, we didn't give you the information, or the party didn't give you the information. So, Your Honor, that's the issue, isn't it? Well, that needs to be told. But right now, we don't know why we were excluded from that. Mr. Steele, I want that to stop. Stop. Just right. Stop at this point in time. Because Article 1, you already said that. You already said we're the Constitution and we have the right to be present. All right, Mr. Wiener.
So, would you have just told who the source was? What's the big deal?
No. You would not. No, you would not. He's not snitching. No, you would not. No.
Now, I'm feeling we've gotten it fixed. So one of the questions I was going to ask you actually while this was happening was, hello?
Well, yeah, you can't. First of all, both lawyers did not prepare for everything. And
all right, take Mr. Steele into custody, please.
The memes and clips that have come from this. Like,
so now look, he's taking off his jacket and his tie. He said, "Take him to jail."
Like the gangster background of taking off his top. This is so one of the defense attorneys doing this for his client. He's doing this for constitutional rights, criminal defendants.
Exactly.
40 minutes into this video already. Hit the like button if you haven't. We still got a lot to get through. But I mean, this is wild, right? of like
when he takes off and makes the shirt walk, I could kiss him. I'm telling you, I don't know, Steele. I don't.
Exactly.
I mean, you could just mic drop. That's, I think, the Georgia Association of Criminal Defense.
Yeah, the report accordingly went on to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right. Yes, sir, you certainly may. Mr. Williams does not wish.
On his way out, without his tie, without his jacket, he's still lawyering. He's still protecting the record. I mean, this is pretty awesome. This is like a
This is awesome.
To the end.
literally.
Yes, sir, you certainly may.
And he still asks. He's still like, "Can I say one thing, Your Honor?" Still respectful. Still, if the judge would have said no, he would have kept walking to the jail. It's special.
Mr. Williams does not wish to go forward with being here parts of this trial without me present, and I can't learn about it by watching online. So, for that reason, additionally, I asked for this trial, and I assume you denied, but I'd like you to deny our motions for this trial. You denied the other. I denied your motion, but I'll certainly take that under advisement, sir.
I mean,
He asked for a mistrial.
Knight said, "How do you get 25?"
He has no
It's
counsel.
hard. It's hard. It's unusual. Okay, I think this is the next one. Yeah, we're gonna get, so Steele gets some lawyers. I think this was from today. I'm all over the place though with this one. As far as timing goes. But let's listen to some of the arguments his lawyer made.
Now,
Yeah.
check
Can I
this
give you a
out.
little background?
Check
I
this
know-
out.
I mean, obviously, I don't know for a fact, but I can tell you what happened here.
Okay.
What happened here is somebody called it. Well, as you know, this last weekend we were at the Florida Association of Criminal Defense Lawyers. This is the Georgia Association of Criminal Defense Lawyers. Someone called the Strike Force. That's a group of lawyers that are prepared to get in their cars and drive and defend another lawyer that's in trouble. In the courtroom for some leak, lawyers jumped, dropped whatever it is they had, and came over here to defend Steele. That's the way it's supposed to work, so that criminal defense lawyers are not alone.
Strong-armed by the judge, and the judge was not acting appropriately. The judge was hiding things. The state was hiding things. It was shady. They have a right to know, and he stood up for those rights, and he stood up for his client, and the judge was going to throw him in contempt, or throw him in jail for contempt. And again, honestly, potentially helps his client. And I mean, I don't know how it helps anybody get a mistrial. I just can't imagine how miserable that's going to be in this case. But I mean, that's pretty important. Netwoman said the judge and Steele arguing reminded me, did you order the code red? I was waiting for Steele to say you can't handle the truth. Good to see you, Papa Dragos. Yeah, I mean, it literally felt like a movie. But let's hear what these Georgia Association.
This Ashley Merchant, she the
I
president.
think was one of the ones that won one of the big motions. And
She's president. She's also president of the Georgia Association of Criminal Defense Lawyers.
right. So let's listen to some of what she has to say. These are the lawyers that jump on it and represent Steele immediately.
As to how that information was disclosed, that's a problem. That's a real problem. That's why it's of such an issue for the court at this point in time.
Judge, Mr. Steele has a right to make a motion like this. If there were,
He does. I'm not saying anything, but but he's kind of put himself in a particular position he's in.
No, Judge, I don't agree. I believe that.
I'm gonna disagree. Okay.
I believe that the court has put him in that position.
No.
He cannot be held in the law states McClary, which I cited to you earlier.
And it's true that direct summary contempt, which arises in the presence of the court, intends to scandalize it and or hinder or obstruct the orderly process of the administration of justice. The preservation of order and decorum of the court is exempt from due process requirements of notice and hearing. That's even Moody goes back to 1974. So
You're arguing about whether or not his due process rights were stepped on by not giving him notice and allowing him to have a hearing and call
Exactly.
witnesses, which she's saying she wants to do, and they can prove he's actually right why he's not giving up his source. And again, that's the part is we're saying, yeah, he gave up his source. We don't actually know, right? We don't know if it came from his client. We don't know how he got it. So we don't really know how all that fits together. We're guessing on some of the stuff that everybody's dropping kind of breadcrumbs.
believe that Mr. Steele, he can file whatever motions, but actions in this case. I just want to know who told him this. That's all. I'm not asking him to release or otherwise tell any conversations, but I just want him to tell me that.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for him to answer your question does not mean if it's a question that the court is not permitted to ask. Yes.
Okay. Well,
So again, violating a court order, you can hold that person in contempt. But if the court does not have the authority to ask a question, how many of those are there, right? Like how many of those actually exist? Because she's right, but it's a pretty small number of questions, right, that the judge would not be allowed to ask.
Oh, absolutely. And I want your hopefully your listeners to listen, because the law and the judge is wrong.
The judge is wrong.
That this is a criminal contempt.
Yeah, she's wrong, and he's wrong, and she's right.
Yep.
Yeah, it's really interesting. And Nina said, make sure you show that part. I hope we do. I have a bunch more clips that I tried to put as much into this video as we possibly could to try to get as much context as possible.
Listen, this is a question the court's permitted to ask.
And it's our position, if we had a hearing, we could explain to the court why he is not required. First of all, the court accused him of eavesdropping. That is a crime. He has a Fifth Amendment privilege against answering those questions. Rule 1.6 protects all confidential information that is gained not from your client, but in representation of your client. He has the ability to protect that information. But we don't even need to get there, because he can't be held in contempt, and you can't threaten him with contempt for presenting a motion in good faith. He presented a motion in good faith that he believed there were ex parte communications. You are a witness to that, because it's my understanding that you were part of those ex parte communications. They can't be ex parte if you are part of them. By nature.
Okay.
And you have to be involved. Therefore, you have to be a witness. So you are a witness. You cannot also.
But you got the information. But here's the thing: you got the information allegedly from an improper methodology. I'm not saying that he eavesdropped. Okay, I said that one of the things is it's either one of two ways. He either eavesdropped, which I don't believe he did at all. I don't believe that for a minute. But I do believe somebody did tell him what was the sum and substance of the court's conversations, and that would not be permissible.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody, and he got some information that
Because the judge didn't do what was right.
Exactly.
Something in motion to where this potentially wrongful act was done, where it was leaked as improper ex parte. I mean, she crushes. I've never heard of her before this, but she crushes. Like, she now is this judge, in my opinion. Do you agree?
Oh, I agree. Well, the problem is, he gets tripped up, and
I'm not willing at this point in time. I'm going to hold him in contempt. So at this point in time, is there anything else you want to tell me?
Yes, Judge. There's quite a few other things. So first of all, we would ask for you to be recused from this case because you are a witness. Necessarily, it cannot be an ex parte proceeding without you being a witness to this. So you are a witness to this proceeding. Therefore, yes, to the contempt. To the contempt. You are a witness to the contempt. So you have now, and if it's criminal, which is what you're saying it is, Mr. Steele is entitled to all the same due process rights that Mr. Williams and every other defendant in this courtroom is entitled to. He's entitled to those. One of those is to have a fair and neutral judge decide his case. One of those is to have a judge who is not also a witness in the proceeding deciding whether or not he's in contempt. This needs to be heard by a different judge. Right to subpoena witnesses, he has a right to an attorney, he has a right to due process notice, to show cause hearing, notice of the alleged violation, whatever rule it is that the court believes, and a hearing where he can call you as a witness. You can testify. You are necessarily a witness. You can't, for it to be ex parte, you have to be a witness. It can't be both ways.
I'll let the appellate court decide that. So, anything else?
No, we'll file a notice of appeal.
I'll let the appellate court decide that. I got to be honest, I hate when judges do stuff like that because the appellate process is so hard. It's so hard to win. It's so laborious. It takes so long. It's kind of like them saying, haha, I don't have to. No.
Okay.
And we have the order reduced in writing.
I'm going to do that right now. I will point out Mr. Steele has, in fact, this is part for the record in this case.
And his wife filed the paperwork as this was going on. His kudos to his wife filed the paperwork. And now the appellate court, as of today, look, and the appellate court, as of today, says going to the Georgia Supreme Court. Oh shoot.
It's about what an objective.
Oh shoot. I hit the wrong thing, y'all. Let me get back to where I was.
Final motion about this. Could the appeals court declare a mistrial?
Now, normally what they'll do is they'll send the case back to this judge with directions about what he should do. So, like, the judge should declare a mistrial, or the judge should have a hearing on this. They'll send it back with directions.
Benjamin asked, did the judge forget which court he represents? I mean, it's kind of wild. This is really wild.
You know, one thing too, I think that because we're at this point, I think that if I remember right, Steele is now back in the courtroom.
I believe he is. Yeah. So
Steele is back in the courtroom. We missed the part where, because we have a lot here. I'm sure you can't show everything.
Listen, all I got to say. Shout out to Steele. He did this thing, and backup came within 2 hours for him. That's how it's supposed to be done. He went all the way out. He deserved every money. Young Thug, welcome home. Because if you don't get out of this one, you getting out on it on appeal. Thank y'all. Like, share, subscribe, leave a comment, and share the video. Thank you.